this list may be taken up on Thursday because I have to file an affidavit.
You have filed affidavit.
I'll file during the course of the day or tomorrow. So let it be taken up on Thursday, Lord.
Motion.
Admission.
Let me on Friday.
Lordship, Friday, I think the other side has difficulties, and it's a very important matter, Lordship. That pipe connection, household pipe connection.
On the prayer of MS. M. Hazarika learned it. Counsel for the petitioner. Please take it on Thursday.
Obliged.
Like to mention WPC 2783 of 23. I'd like to withdraw the petition, so may I kindly put it up for
When tomorrow?
today even it's okay.
Tomorrow.
May please, Your Lordship, back to mention item number 1. Here, this is the bail application. We have filed an additional affidavit to bring into record. So kindly maybe tag with the main record. It is already been filed.
Then Wednesday.
No, my lord, this is very important. It is already there today.
Item number 1, you are mentioning at 10:30 additional affidavit.
My lord, already it is there. It's just one particular para is there. That is to bring it to record that there was an error in the error.
Wednesday. Okay, Mr.
WR Mediman.
W.R. Medhi, learned counsel for the petitioner has submitted that an additional affidavit has been filed today.
No, on 25th, my lord.
An additional affidavit has been filed on 25th 5/8/2023. As the said affidavit is not with the tag to the record, let the case be listed on Wednesday with the said additional affidavit on record.
Obliged.
Well, I beg to mention item number 41 and 42, my lord.
41, 42. Yes.
This matter may be taken up, my lord. If these two matters may be taken up, my lord. If not
Okay, we'll
serially,
try to take up.
yes, my lord. Up.
Maybe the Lordship. My lord, prayer for a listing on is in Musa, my lord.
One is the
On Wednesday, my lord.
file correctly or defectively?
Correctly, my lord. Correctly, my lord. On Wednesday, my lord.
Subject matter.
Subject matter is about tender, my lord. I participate in the tender, my lord. In IIT. Obliged.
May I pray for Lordship's indulgence for listing of a motion matter tomorrow, Miller. There is an urgency, Miller. The bank account of the petitioner has been freezed, and that has resulted in non-payment of the labor wages to the T state workers, Miller.
Wednesday.
Miller, can
They're
it
not
be
so urgent.
because Thursday, Miller?
Because maybe definitely there are other proceedings.
No, nothing. The
Wednesday.
bank has freezed, Miller.
Wednesday.
The document is that,
Wednesday.
Miller.
Appreciate, Your Lordship. Lord, item number 12, Your Lordship. Can you take it at 2, Your Lordship?
Hmm.
Item number 12. Take it at 2, Your Lordship.
2.
My lord.
Why?
I
You
have
should list
another,
before 2.
another matter in another court, Your Lordship. That is why.
I know.
Must have let.
May I please, Your Lordship? Lordship, I beg to mention read petition for listing admission column. Matter,
Admission column.
Yes.
Subject matter.
read petition.
Subject matter.
Epidicial, Nirumeri versus Epidicial.
Hmm?
No, I've been denied the electricity by the respondent. I've been denied the electricity by the respondent.
Friday.
May I please, Your Lordship? I beg to mention item 37, Lordship. I have instruction to withdraw this petition, Lordship.
MS J. Abbas,
Lordship.
learned counsel for the petitioner, has submitted that he has instruction
The direction has been complied, Lordship.
to withdraw the petition as the direction made in the order against which this contempt petition has been filed, has since been complied with.
Lordship.
In view of the above submission made by Mr. J. Abbas, learned counsel for the petition, the contempt petition is closed.
Obliged, my lord.
May it be the Lordship. I beg to mention item number 24, Lordship.
24, yes.
For the respondent, Lordship. This can I'm paying for adjournment, my Lordship.
You are respondent.
Yes.
Or which respondent?
12, Lordship.
12. Okay.
Conducting counsel Ace Burwa is suffering some fever.
You are Mr.
I'm PP Phukan.
PP Phukan.
Yes.
Adjournment for what reason?
Contracting Council AS Bora is suffering from fever, Lordship, and eye infection, Lordship.
Have you informed the other side?
Lordship,
Mr. PP Phukan, learned counsel for the respond number 12 has prayed for listing of the case after a week on the ground that Ms. Arguing Counsel, Mr. H. Borua is indisposed to stop. It is submitted by Mr. Phukan that consent has been taken from the learned counsel for the petitioner as well as the other respondents to make their prayer. Prayer is allowed, list the case after a week on it.
obliged.
Lordship, item number 22, Lordship. In this case, I'm seeking an adjournment because other side counsel is suffering from conjunctivitis. He has informed me, Lordship. It's a case, Rishi Buragoy.
H. Borua.
H. Buragoy is suffering from conjunctivitis.
Okay. Mr. P. Sharma, learned standing counsel KFDC, has submitted that the case be adjourned for a week, as he has been informed by Mr. H. Buragoy, learned counsel for the petitioner, that Mr. Buragoy is indisposed. Considering the ground cited, Thomas, the case stands adjourned for a week. Office to list the case after a week when it will be.
Highly obliged.
May I please, your lordship? I wish to mention for listing of a WPC.
By it.
I have to mention for a listing of WPC.
Subject,
It is a lease of municipal shop.
you know,
My lord,
next week. Motion,
No, my lord, orders.
next week, Monday.
Alright.
May I please, your lordship, I beg to mention for listing of a writ petition, my lord, for admission on the next week, 7. Obliged, my lord.
7, no, 9. 7 will be too much. 7 is Thursday,
My lord. 8, my lord.
11,
11. Well, it's convenient 12, my lord.
11.
11. Obliged, my lord.
Please, your lordship. Your lordship, I am praying for listing of this writ petition in the admission column. I am praying for listing of this writ petition in the admission column.
Subject,
Subject, it's related to a fair price shop where the supply of rice has been stopped.
next week, next. What next? Today is 18. Any day, 11 to 11 to.
May I please, the lordship, with consent from other side, lordship, we mention item number 43, 44, and 45, lordship,
43, 44,
and
40.
45, lordship. As on date, dusty service has not been completed, lordship. So matter may be adjourned for 1 week, lordship.
Mr.
MS Mondal.
M.S. Mondal, learned counsel for the petitioner, has paid for adjournment of the cases for a week. It is submitted that consent has been taken from the learned counsel for the other side to make the prayer. Lease the case is separate order, huh? Lease the case after. When it
Obliged, lordship.
office.
May I please, your lordship. Lord, by prayer for listing this matter, this is contempt matter, my lord, and on last 4th of April, my lord, matters is late over. Only small amount is involved here and admitted amount.
11 in
Obliged,
13,
my lord.
15 any day.
Yes. Only for our anxiety, I have to mention item of 46, Lordship. That tier 1, tier 2 matter, Lordship. Let me take up the matter for early, Lordship.
46. Yes, no, it's taken really hardly 14 motion.
My lord, please, my lord, on Monday, it is a holiday, my lord. Can it be on Friday, my lord, this Friday?
Which one?
My lord, the mention I did for listing.
What is the
WPC.
subject?
Lease of a municipal shop.
Friday.
Alright.
Daily list for motion item number 2.
Mr. Lordship,
Yes, madam, no additional affidavit.
yes, Lordship, we are going to file it only today. Because Lordship, the petitioner had some personal
MS
difficulties.
to the Sen La, counsel for the petitioner, has paid for listing of the case after a week in order to enable her to file additional affidavit in deference to the order dated 30/11/2022. Already 9 months. You have taken 9 months to file additional affidavit.
The petition-
Then you
the
come for
petitioner
a-
had some
come to
personal.
plea for
difficulties.
urgency. MS. As Sharma learning standing after PWD for all the respondents is in attendance. The praise law leaves the case after 2 weeks. 2 weeks for you.
Item number 3.
Same.
No, Lordship, for item number 3, I would like to pray for withdrawal. of this petition.
Okay. MS.
Liberty to file afresh.
Learning counsel for the petitioner has submitted on instruction, the petitioner wants to withdraw the petition. MS S. Sharma learned sending out the PWD for all the respondents is in view of the above submission made by students, the petition is dismissed on the 12th.
Item number 4.
Please, Honorable Court, my lords. This matter arises, my lord, actually as a dispute of business in an agreement. Now we are praying for appointment of an arbitrator, my lord.
What is the arbitration clause?
Arbitration clause is in clause 10 of my agreement,
Clause 10.
my lord. Which is affixed as. What is the annexure? Deed of.
Page?
I'll just get my lordship to that. Deed of partnership at page 19.
Page 19.
Then we have the arbitration. Where is the arbitration clause? I apologize to my lordship. I had read it and I forgotten, my lord.
What is the notice?
Notice I sent, my lord, my notice is that page 51, it's the,
Okay, asking him to.
my lord, rendition of accounts,
What is it?
rendition of accounts of return of 1,23,44,560 only. And exit from the, in terms of clause 2 and 17 of the partnership deed between us. And I asked.
What is it regarding arbitrator?
In here, my lord, page 27, no, in the interest, in the notice, my lord,
Notice.
I have referred to our partnership deed, which is at page 27. I just
But regarding arbitrator,
page 27.
that let us appoint an arbitrator.
My lord, because I'm getting no response from respondent 2 and 3. They
But
have
you-
diverted money to buy.
Right, but you have to invoke arbitration clause. Is it not? I'm not very conversant, but still, you have to invoke the arbitration clause. Otherwise, rendition of accounts is jurisdiction of civil code
If it is on
under partnership account.
in clause 17 and of the partnership and all that, we have asked for the exit from the
Yeah,
partnership, to which they have not replied at all. So
Otherwise, these are governed by the partnership act.
now we have no option.
Who is that
25.
invoking arbitration clause?
My lordship would come to page 27.
No. Notice invoking arbitration clause.
In my legal notice, I have invoked the entire partnership clause itself, my lord.
Oh.
Expecting a
There
reply.
has to be specific.
Specific.
Is it not?
No, not specific, my lord.
Is it not
Non-
required?
It's entire.
Tell me the law, is it not required
Right.
to invoke the arbitration clause?
The entire
specifically?
partnership, not my
You
first.
go on invoking everything will not do. Otherwise, all are jurisdiction of the civil code, dispute between partners.
I understand, my lord, but they don't want, but my client is instructed
Is
not.
there any single word that arbitrator be appointed?
My lord, if my lordship comes to 25 of the,
Look, clause may be there, wait
Yes,
for
yes.
notice.
just my lordship would bear with me.
Uh-huh.
That all disputes and questions in connection with the presence.
I have seen it, 25, I have
My lord,
seen it
my
now,
lord, my lord. Now, based on.
myself.
based
Now,
on
where is
that-
the
Based on that.
long notice, space.
My notice is that page.
51. Any whisper about any arbitration? Any whisper about arbitrator? Show me. You cannot come with a arbitration petition before the High Court
My lord,
under section 16 without following the proper procedure. Arbitration account.
I simply demanded that the amounts be returned, my lord.
That will
And
be
for
partnership
that-
acts.
For that,
That will be partnership act civil code.
there was no.
Not a whisper about any arbitration or not a single word about arbitrator.
11(4), my lordship has the discretion.
Oh, no, not that.
Of the
You
section.
cannot come here just for the. This is not properly served notice.
So this notice was actually to get a response from the. They didn't
I don't think.
litigation between each other.
Better you serve a proper notice
Read some-
that I want to. Because arbitration clause says, but
Section 8 is it doesn't within each other, but
single arbitrator,
my lord,
then board of arbitrators,
my lord,
then umpire.
there is no response from the other side. So even if I propose,
Where is the question that I'm going to invoke arbitration clause? All these are different things. I think the other side has to be put on notice properly before approaching the court, invoking section 11. Is it not?
the lordship would see that there was a 60-40 division of partner.
Rendition
But-
account.
But the partner two, respondent two, is described in the partnership deed as a sleeping partner. So, only to get
Chaudhary,
licenses and so on, my lord.
this is a partnership
My lord.
business,
Partnership at will, my lord.
partnership at will.
So when you had the chance to even get
When if I look at your deed of partnership,
my lord.
this is not a partnership.
No, this was actually
This is
right.
registered deed.
My lord.
This is not a partnership farm. Partnership farm is to be registered
It is
before
just a registered deed.
register of farms and societies. This is association of persons.
In this case, my lord,
This is not a registered partnership farm.
in this case, my lord, I am a businessman in Bangalore, and the respondent who approached me saying that why don't you expand to the northeast?
It's a Chaudhary. Come to page 19.
So the basic,
Come to page 19.
my lord, I'm with my lordship on page 19.
This is a deed of partnership registered before senior sub-registrar Kamrup Guwahati. So this is an association of person, but partnership farm is to be registered before the register of farms.
No.
Then only it becomes a registered partnership farm. Your farm is not even a registered
No,
partnership farm.
it's just a deed of partnership between the two. Just deed.
It may be a contract or whatever,
My lord.
but where is the invoking clause?
Invoking clause is inherently there, my lord, as part of the.
Not
25.
inherent, we are not going to. Court is not going to examine for that.
My lord. So what
There is nothing.
though they have mentioned that the.
Put the other side on notice that I am going to invoke the arbitration clause,
My lord.
and my inclination is to appoint this man as the arbitrator. Then it is a different thing.
We are actually approaching the court because we are not from here. So we-
That doesn't mean you would not follow the proper procedure.
As I'm saying, we don't
That
know. any-
doesn't give you license,
no,
just
no,
because
no,
you
not
are
at all.
from
My lordship has
somewhere else.
misunderstood my submission. My submission is that I do not know anybody here to appoint as arbitrator. That's why I approached the court.
Then you say, right, but you have to put the other side on proper notice.
My lord.
That I want
To invoke the
invoke arbitration clause, and I want the court to appoint an arbitrator. This much notice has to be given.
So with the.
Is it not?
Leave of the court, my lord, then I may.
What leave? This,
May withdraw
you,
this at the moment
you
and.
properly introspect. We'll post it on Friday.
my lord.
But if this is a notice, as per procedure, satisfy me, then only I could
It
proceed.
will be placed on the fifth, my lord. I would be out of station for a little.
It is up to you.
Between
What
first and fourth, I would not be here, my lord. So
will
on the
be?
fifth,
Which
if
date?
it's convenient to my lordship,
Huh?
convenient to my lordship on the fifth,
11? 5th is holiday.
then any other day, my lord.
11th
11th, I'm with my
Oh.
lordship. I'm with my
On the-
lordship on the 11th.
on a prayer of Mr. P. N. Chaudhary, and counsel for the petitioner lays the case on 11/9. Because 5 days are holidays in between.
Obliged, my lord.
But you want to
I'll look into,
place the things properly.
I'll look into the matter and meanwhile I'll send the notice. Deeply.
Item number 5.
May it please your lordship. My lord, I have filed additional affidavit also. Before that, my lord may kindly come to page 28, your lordship. And your lordship will see it was executed in the year 11 to 1992. With your lordship, and your lordship may skip and kindly come to page 36, my lord, 36. May I read your lordship? Clause 7. The contractor's request for making available reasonable area of the railway land for his work site office, stores, labor, hutments, stacking place, or for materials and any other person connected with the work will be considered and provided by railway free of charge on such terms and conditions that may be prescribed by the purchaser through the purchase officer. Now your lordship may kindly come to annexure page 144. It starts from 126, annexure 3.
144.
Before that, 126, it starts from 126, my lord, annexure 3.
126.
126, your lordship. And my lord, your lordship will see awarded by Northeast Frontier Railway Maligaon. Why I am saying for the purpose of jurisdiction, my learned friend has raised the question of jurisdiction, my lord. Otherwise, matter is covered by this honorable court decision, your lordship. So agreement was executed with NF Railway Maligaon, and your lordship may kindly come to page 144 regarding jurisdiction. 144. Clause 23, your lordship. Law governing the contract. This contract shall be governed by the laws of land being in force, irrespective of the place of delivery, the place of performance, or place of payment under the order. The order shall be deemed to have been made at the place from where the acceptance of tender has been issued. Thereafter, my lord, jurisdiction of courts. The courts of place where the contract agreement has been signed shall have the jurisdiction to decide any dispute arising out or in respect of the order. Now your lordship may kindly come to policy, page 50, my lord, annexure 4.
Page
50, my lord. No, my lord, I'm sorry, 217. And I'm taking a 207. And your lordship may kindly come to page 224. Annexure 5, 224. Clause number 7, fixing of land value. The market value would, however, be required to be taken to serve as a base value for working out rental fee payable. This shall be fixed on the basis of land value of the surrounding area as on 1/1/1985, as determined from the railway authorities and from the following. On the basis of this circular, your lordship, similar situated person approached this honorable court. And this honorable court, my lord, that your lordship will find I have annexed judgment, your lordship. I appeared in this matter, your lordship, page 237. Daya Engineering, same issue. Only in that case, there was no contact here. In this case, there was no contact. And my lord, kindly come to page 241. Para number 15. At this stage, 241, my
Page?
241, 241. Judgment starts from 237 and relevant page 241, para 15. May I read your lordship? At this stage, it is relevant to reiterate that it is the mandate of all circulars, be it the 95 or the 2 circular 205 that I have shown, my lord, that no plot of land can be allowed for commercial use by private parties without entering into a license agreement. In the instant case, it is an admitted fact there is no license. Here there is license, your lordship, agreement between the petitioner and the respondent authorities. And the petitioner has been allowed to use the land in question without any agreement which allowed to be used by the petitioner so and so. It is in respect of agreement. Your lordship may skip and kindly come to para 18, page 242. Consequently, in view of the above observation, the impugned notice of demand dated so and so is interfered with a direction to the respondent authority to calculate the land value and consequential licensing fees on the basis of clause 7 and 9 that I have read, your lordship, of the master circular dated so and so till the license agreement is not entered into by the petitioner along with the respondent authorities. It is respondent authorities so and so in view of the mandate of circulars that licensing agreement is a must, shall take appropriate steps as envisaged under the law against the petitioner.
No, what is the story here?
My lord, here your lordship.
You have taken me here and there.
My lord, story is, my lord, it will be easier, your lordship. My lord, land was allotted to me for the purpose of manufacturing sleepers, my lord, the railway sleepers. And it is, my lord, continuous process, your lordship. For the loading and unloading, my lord, certain lands where it was allotted. As per the agreement, they ought to have given, it should have been given free of cost. Even assuming it is not given in free of cost, it has to be on the basis of master circular, your lordship. So that they have not done, and they have issued this impugned demand notice. Otherwise, matter is covered. Page 229 is the demand notice.
I will not readily agree that matter is covered
My lord.
without knowing the.
My lord. Page 229, my lord. Subject, impugned notice. Allotment of additional land on license for sleeper factory at NGP so and so to the existing land occupation by so and so. These are the reference of master. In reference to the above white board letter dated so and so DM so and so so and so. Their proposal received from headquarter means Guwahati, your lordship. Licensing so and so land at NGP to so and so for sleeper factory examined in the light of board circular so and so for taking necessary action at the division level as advised by so and so. In view of that, it is requested to kindly deposit the license fee of rupees 86,19,900 so and so, and expedite towards the execution of land license agreement for the additional land which is under your occupation. And it is not calculated as per the master. Our grievance is, my lord, it has to be calculated on the basis of master circular that they have not done. My learned friend on the last occasion has raised the question of jurisdiction. So that I have shown, and in fact, I have additional affidavit also. So land was allotment later and all I have annexed, your lordship. It was given by Maligaon, your lordship. So this court has jurisdiction.
All these are not subject matter of arbitration.
My lord, here because already this issue has been dealt with by this honorable court regarding master circular and all.
No,
And my lord, apparently, my lord,
because what was the. Let us see.
my lord,
This was decided after 4 years.
my lord,
That other petition
my lord,
was decided after 4 years. We are into the motion stage.
my lord, at this is a notice.
Because the law is also there, if other side does not raise, or if the court does not raise the issue of arbitration and a number of years have elapsed in the meantime, then
This is
no point remanding back for arbitration.
Here
Court has a discretion to decide.
my lord.
Now the question is whether this matter is subject matter, these issues are subject matter of arbitration or not.
My lord, in my humble submission, so far as
Is it, you have a contract agreement before you.
through your lordship,
Where is that? Is there anything
Arbitration is there, my lord. Clause is
Where
there.
is there?
That your lordship will see. That I will satisfy, my lord, why this matter is not required to be sent for arbitration, my lord. Contract agreement page 100 and
226 is not easily
true, your lordship.
concluded
This is the
contract,
discretion, my lord.
concluded contract. It is not a case of entering into a contract.
My-
You
No,
have
it is ongoing, contract is
ongoing since 1991,
We are working.
32 years. So it is a subject matter of arbitration if it is, that clause is provided in the contract.
For arbitration is there, but here is the clear cut violation of my lord circular issued by railway. And my lord. In fact, the arbitration was not taken by my lord, my learned friend,
But court can ask.
my lord, that I will satisfy, my lord.
Where is the arbitration?
That
clause?
I,
Lordship, page 173.
yes, your lordship. Clause number 2903.
I think these clauses are exhaustive in nature.
My lord,
These clauses are exhaustive in nature.
my lord. But my lord, may I say, my lord, so far as arbitration, my lord, that your lordship, that here the case is the violation of my lord circular issued by our railway itself, your lord, number one, your. The issue has already been decided by this honorable court, number two, your lordship. And my lord, it is not that it is not well within their knowledge, your lordship. They are repeatedly demanding it. May, in my humble submission, this may not be, my lord, that arbitration may be
No,
sent for-
in the other requisition, whether the issue of arbitration has come for discussion at any point of time.
I don't think so, my. I don't think so. But my lord, may I submit my so far as
But
226
226 is just for, this is a discretionary relief.
to your lordship.
And the law is clear when in a case of concluded contract, if the parties have arbitration clause,
My lord.
right? Then if the matter is covered by arbitration, then it has to be normally, ordinarily resorted to unless exceptional case is made out.
My lord. That I
Exceptional case, just because the other judgment, there was no whisper about arbitration.
no wish.
No whisper, simply proceeded
my
because
lord,
that was decided after 4 years. Now, if question is not raised at the very beginning and the matter and a number of years have elapsed, at that point of time, court may decide, no, it is
Here,
now-
my
it is
lord,
too late to refer it to the arbitration, let us decide.
My lord, here they are not raising when the
But
court
court is
is
asking.
asking your lordship.
Court
But
is
for that,
asking.
my lord, may the concept of that alternative remedy, my lord, what we are saying, I think, my lord, there is no alternative remedy to 226, my lord. It is up to your lordship. My lord, arbitrator cannot
That
do
is also a statutory remedy,
which one, your lordship?
arbitration. There is a
That is-
statutory framework in place.
Your lordship.
Are you saying
that
that this has no value?
I'm not saying so, my
Huh?
lord, but that is not.
One cannot come at 226 just because for the sake of it.
I will satisfy, my lord, that your lordship may exercise.
And now you have to satisfy me on this point.
My lord.
Just
Your lordship may-
because the issue of arbitration is not discussed in the RAJ at
Earlier
any
one.
point of time. Show me
But my
that
lord, when
in
the
spite
issue
of
has been
arbitration clause,
My-
let us decide the issue.
true, this is not, but when the same issue has been decided by this honorable court, whether sending to
May
the-
not be, there is slight difference. There was no agreement in the other case.
but the honorable, this honorable court held that
Yes, madam, you file your affidavit.
Lordship, we have raised the question of jurisdiction, Lordship, because the demand notice, although it is signed by the
Jurisdiction, you have to come with the statement, affidavit.
Lordship.
Sometimes jurisdiction is a question of fact as well as law.
Because Lordship, the demand, although it is signed by
No,
the
Mr. Goel has shown me that otherwise you have headquarter in Maligaon. Is it not?
Lordship.
And where is the exact agreement, contract agreement?
Contract agreement, it's a Lordship, I'm showing Lordship, contract
126.
agreement. 120,
126 and page 144, your lordship.
The
Jurisdiction,
original one, original.
original
Don't be, show me
190,
the type one.
true, your lordship. Type 1, it starts from 28 to 8,
Hmm?
page number 28
Page number
to 8, my lord, annexure 1,
28.
my lord.
This is type.
Type original one is there, my lord.
Ah, show me the original.
Okay. Page 73, my lord. And page 74, your lordship will see Maligaon. Signed by General Manager, NF Railway, Maligaon.
Ah, he is the general manager of Maligaon.
Yes.
Now, page 29. For and on behalf of the contractor, Guwahati. In big letters. Where did you find Guwahati? In page 74.
74, your lordship will see General Manager,
No, no. Page 29.
29
You have
type.
typed
type
for and on
is wrong.
behalf of the contractor, Guwahati.
Guwahati, it is missing, my lord. Typing mistake. Typing mistake.
Then-
but Original, my lord, is Guwahati. My,
Can I not accept as an deliberate act?
my lord,
It is quite,
me,
it is missing, conspicuously missing in page 74.
my lord. It goes against me.
That is why
It goes in.
I don't believe in type copies.
That's why. True, your lordship. That's why, my lord.
This is made maybe bona fide or not bona fide.
My lord, but it goes
This Guwahati is,
missing, my lord.
and
But in
just to press your point that it is executed in Guwahati.
but original, it is Guwahati.
Original not there. Your side is not there. For and
Original-
on behalf of the partner contractor, so and
It's
so,
type copy, my
Coach
lord.
Bihar.
My lord, it is type copy. Page 74, my lord. Can you see? Page 74,
I have seen it.
my lord.
Where is Guwahati?
Guwahati is there, my lord.
For and on behalf of the contractor,
lord,
Guwahati.
it-
Where is that?
General Manager, Maligaon, Guwahati.
Oh, that is on the right side. What about the left side?
Or address is there, your lordship.
And this is Coach Bihar.
My address is Coachbehar, but it is executed at Guwahati, my lord.
Don't, Mr. 29, come to page 29, this Guwahati. Where it is reflected in page 74, you have typed Guwahati in big letters. Left side Guwahati.
Oh, my lord, it's also been this side. It came to this
Ah.
side. Typing, my lord, it happened.
Then why should I believe you?
My lord, original, if you also will see. Original Guwahati is there, man. In original, my lord, 74.
Oh, is it a ploy to mislead?
No, my lord.
Huh?
Never, my lord. I will lose case, but I never lose court, your lord.
But then it is
It is typed by,
prima facie evident.
my lord, it is typed by, my lord, them, that.
Don't blame
But in
others.
original,
Don't blame others.
74,
Don't try to blame others. Page 74 is clear.
Page 74 is clear, my lord.
We do not know whether this general manager has gone to Siliguri, Jalpaiguri, or
But
you have come to Guwahati.
additional affidavit, my lord, can you see?
Let them file affidavit.
My lord, additional affidavit is Guwahati, my lord.
Let them file affidavit.
In fact, Lordship may kindly come to page 127, Lordship. And according to page 127, the acceptance letter is of New Jalpaiguri. And demand notice is also by the Katihar Railway Lordship, Divisional Railway Manager Katihar
You
Lordship.
bring all these points only that question of fact and law, this is a
Lordship.
question of jurisdiction.
That-
It appears. And whether this arbitration clause,
Because Lordship,
We
just
should-
now I have given one instruction, written instruction, Lordship. And page 17, that the, as per policy also, Lordship, dispute resolution. Page 17, clause 8. 17, I have marked